Welcome to HOP Minute Minis. Today we'll talk about the Supreme Court and how liberal and conservative justices decide cases. But first, remember, in a constitutional republic, we the people choose the politicians who pass the laws we live under. If we don't like the laws they pass, we can vote them out of office. So how do conservative justices decide cases? Their philosophy is called original intent. This means they decide cases based on the law, not their personal political beliefs. They read the Constitution and statutes and they interpret them according to their original meaning. They believe laws and the Constitution can change, but we the people decide when they change, not the Supreme Court. They believe some disputes are not federal issues. When the Constitution does not give the Supreme Court authority over an issue, conservative justices push it back to the states or to the people. Remember, the 10th Amendment says the powers not delegated to the United States by the Constitution are reserved to the states or to the people. Now let's talk about the liberal judicial philosophy. It is dramatically different. Liberal justices are judicial activists. They claim the Constitution is a living, breathing document. This means they believe the Constitution and laws mean whatever they say they mean. Often, they decide cases based on their personal political biases, not the text of the Constitution or the law. This liberal philosophy is dangerous because it takes power away from we, the people, and gives power to unelected Supreme Court justices who are not accountable to we, the people. In the past, Harvard and the University of North Carolina used race as part of their admissions process. They were sued because using race as part of the admissions process is a violation of Title VI of the Civil Rights Act. Using race is also a violation of the Equal Protection Clause of the 14th Amendment. Both the Civil Rights Act and the 14th Amendment were originally intended to end racial discrimination. Conservative justices ruled that race cannot be used as a factor because the law and the Constitution say it is illegal to use race as a factor. On the other hand, liberal justices ignored the law and the Constitution, and they voted to allow the schools to use race in the admissions process because of their own personal political beliefs. So what do you think? Should justices decide cases based on the Constitution and laws or based on their own political biases? Tell us what you think. Email us at hop2025@aol.com. Thanks for listening.